Good afternoon, folks, and welcome to another episode of BayView Views. In this brief session, I'm going to walk you through Florida's very robust creditor protection laws and how they can help you safeguard your assets from potential creditors. Right? We're talking about responsible creditor protection, right? Not creditor avoidance. I mean, if you owe somebody money, obviously you've got to pay them. But at the same time, we do have a very, we got to protect ourselves from a very litigious society that we have today. So whether you're a homeowner, whether you're a business owner, or simply someone looking to preserve wealth, understanding these protections can really be invaluable. So the first one is our homestead, right? Florida offers one of the strongest homestead protections in the country. If your primary residence is in Florida, it is shielded from most creditors regardless of its value. The exemption, again, applies to properties on up to about a half acre in the city and 160 acres in rural areas. The exception to this, again, it doesn't apply to IRS tax liens. They can always come get your money. Or obviously mortgages, if you put a mortgage on the home, or any kind of what they call mechanics liens that you might have on the property. All those can access that asset. Something that's very cool we do for our clients here is called tenancy by the entirety. And Florida is one of 18 states that allow married couples to title property under this tenancy by the entirety, or we'll call it TBE, and that's extended to bank and investment accounts. So what happens is if only one spouse owes a debt, creditors cannot seize a jointly held asset that's in a TBE. So imagine if a spouse is in an at-fault car accident and they have a liability. Well, this would be a good example of creditor protection for the family. The car would also have to be solely owned by that person that was in the accident for this to also apply. But great creditor protection. This would apply to real estate, bank accounts, personal property, etc. Very common one that we know is retirement accounts. So if you have a 401k, a 403b, or an IRA, Florida law exempts these accounts from creditors. So even in a bankruptcy, these funds are generally protected. However, again, the IRS reserves the right. If you have a tax lien or a family law claim, right, this may override these protections. So if you're going through a divorce or something like that. Life insurance and annuities. So Florida law provides full protection for the cash value and the death benefit of a life insurance policy. And then annuities, again, can serve as a great asset protection tool regardless of its value. Now, caution, annuity protection doesn't apply again if there is an IRS or an IRS lien or a bankruptcy court, divorce-related obligation like a quadro or something like that's involved. You often think about business entities, right? How to title things. So we all know of a LLC or a limited liability company. These do a great job of protecting personal assets from business creditors. And then what we call family limited partnerships, things that use to try to reduce the size of an estate. This helps, again, families kind of pool and protect assets with limited creditor access. So creditors cannot seize an LLC's assets, but they can request, again, seizure of the company's distributions through what's called a charging order. Another one is 529 plans, right? 529 plans are creditor protected as long as the funds are used for education purposes. We did this video probably for this main topic, and that is trust. There's so many people that confuse this topic with regards to creditor protection. Many people think that a revocable living trust, which many people have, as being creditor protected. And this is just not the case. As long as you can modify or revoke the trust and have access to the money or the assets that are in the trust, so would your creditors, right? But there are trusts that provide creditor protection, like an irrevocable trust. So once assets are placed in an irrevocable trust, the grantor or the creator gives up ownership or control. And again, creditor protection is now provided because the grantor no longer legally owns the assets, nor can the creditors get access to them. These are often used for, again, estate tax avoidance with credit shelter trusts, sometimes Medicaid planning, asset protection trusts, special needs trusts, and then what we call ILITs, irrevocable life insurance trusts. if you created a trust to the intent to defraud creditors, that's called a fraudulent transfer, courts again would see right through that and they would invalidate the protection. Another one is called a spendthrift trust. So you might have a very irresponsible son or daughter or beneficiary, and you want to protect them from themselves. Well, a trust with a spendthrift clause that prevents beneficiaries from kind of pledging these assets or selling these assets or giving away their future assets would be protected, right? So creditors cannot force distributions to pay debts, and that's how it helps. And assets are really protected until the trustee distributes them to them, right? So again, common uses are protecting irresponsible beneficiaries from kind of losing an inheritance or shielding assets from a divorce or a lawsuit, something like this. But again, once the money is distributed, the creditors can now seize it. And another thing to note, it doesn't protect the grantor. This only protects the beneficiaries, which again, the ones that we're trying to protect anyway, who may be somewhat irresponsible. Another one that you might hear about is what we call a domestic asset protection trust, or a DAPT. This is kind of a self-settled trust where the grantor can be a beneficiary while still enjoying asset protection. And so the creditor protection allows the individual to protect their own assets from future creditors. These are available in about 19 states now, I think including Nevada, South Dakota, Delaware is one of the first ones to adopt this. Florida is not one of them. So again, you would have to have this trust created and established in another state. But the common uses would be, again, very high net worth individual trying to shield assets from lawsuits. A good example might be physicians or business owners who are trying to protect personal wealth. And then there are offshore asset protection trusts. You might hear about these, some people will kind of explore these offshore trusts, but they're very costly. They face a lot of legal scrutiny in the court system. But again, think about it as a trust established in a foreign jurisdiction with strong asset protection laws, like, the Cook Islands, Nevis, Belize, some type of place like that. And again, what helps is that the U.S. courts have no direct control over offshore trusts. And then creditors, really, they've got to pursue legal action overseas, which is really difficult and very costly. So anyway, again, the final thought, importance of proactive planning, right? So act before you face any kind of creditor threats to avoid any of what we call the fraudulent transfer claims. Obviously, consult an estate planning attorney to kind of ensure your compliance with Florida laws. And again, very confusing topic, so that's why we decided to discuss it today. We hope this helps, and by implementing these strategies today, you can protect your assets for the future. Thank you so much for tuning in, guys, and thanks for watching another episode of BayView Views.